Hi, I'm Jeanette Saltis, Managing Attorney with Atlanta Divorce Law Group, and I'm here today to tell you about the trial process in a family law case. If your case is going to trial, it means that all efforts to settle have not worked, that you've gone to mediation, maybe you've even tried a late case evaluation or a judicially hosted settlement conference, and you and the other side are just not able to come to an agreement, and there are some issues that have to be put in front of a judge. Often we're able to limit the issues that go in front of a judge, meaning some issues settle and then there's a few outstanding that a judge needs to decide. I would estimate that our average trial is 1 to 2 days, meaning an 8-hour day. So 8 hours, maybe 16 hours if it's a little more complicated. There are cases where there will be a need for a full week trial, but that's not the typical case. Know that preparing for your final hearing is a very time-consuming process. Your attorney will have to draft up questions to ask all of the witnesses, also decide what witnesses should be there to testify. So you'll be hearing from your attorney often while you're preparing for the trial. Also make sure that you have the conversation with your attorney about the financial commitment that going to trial means. We try very hard to get cases settled to save the client money. So make sure that you have a plan in place for budgeting to get through the final trial process. As far as what to expect when you get to court, the plaintiff or petitioner is the one who makes their case first. So they will make their opening statement, they will get to call all of their witnesses and present all of their evidence first. Then the defendant or the respondent has the opportunity to do the same thing, to call all of their witnesses and present all of their evidence. As far as witnesses, you can expect that you are going to testify in your own case, and most of the information and testimony will likely come from you. But often there's also a number of other witnesses. These can often be therapists who have worked with the family or certain members of the family who have important information that can help the judge decide on custody issues. There might be a guardian ad litem that's been assigned to your case. That is someone who has done an investigation and represents the best interest of the children and makes a recommendation to the court. They are considered an expert witness, so they will also testify to the court as to their investigation and their findings and what they are recommending to the court. There might be eyewitnesses who have observed certain behavior of one of the parties, and they may testify as well. So you will work with your attorney to come up with a strategy as to who needs to testify and also what documentary evidence, or sometimes there's videos, voice recordings, photographs that need to be presented to the judge to make out your case. So this is, in a nutshell, what a final contested family law case looks like in the courtroom.